Hi, my name is Kaitlyn Downing. I am your union president, and I'm with Gille, your union vice president. And we are here to explain the contract and basically go through it line by line and hit all the important parts so that you know what it is you're going to be ratifying. If you have any questions, please feel free to contact either one of us. You should have both of our emails. And we're also going to show you the contract in the website and all the links.
All right, so this is our contract and associated policies in a PDF form. If you want to access this PDF, you can go to our website, which is uff-phsc.org. So this is our website for our union chapter. And you can click here to join the union. And then the second link right here will take you to that PDF. Now the PDF is all interactive, so you can click on the links and it will take you to those places. If you look at the contract in Chrome, for me, you can't see that they're hyperlinks, so we're going to show you through Adobe because then you can see that all of these are links. So if you're in the PDF, you can click here and it will take you to that part of the contract or the CBA. So our CBA is in this document, but parts of our collective bargaining agreement CBA contract refer to policies that are in IMMs or internal management memoranda or board rules. And then we also have some MOUs or memoranda of understanding, which are like mini contracts. So we had been at impasse for a while, and so we have several MOUs that we bargained in between going to impasse and now ratifying the contract. So a few of those are applicable to what's in our CBA. So here we are in Adobe, and you can see the links here. So these are our hyperlinks that take you outside of this document or within the document. So here we have the contract or CBA, we have the different MOUs, we have the salary schedule from the college, the board rules, and the IMMs. So if you click here, that will take you to the CBA. And then we're just going to go through each of the articles. Kaitlyn and I are going to go back and forth. This first part one, we're going to do articles 1 through 7, and then we'll have a second YouTube video for the rest of the contract. So this table of contents is also clicky or interactive, so you can go here and we'll go to the recognition. So I'll start with the recognition clause. This basically just says that United Faculty of Florida, or UFF, is the exclusive bargaining agent for faculty members in our bargaining unit. So when we first formed in 2018, the PERC, Public Employees Relations Commission, designated our bargaining unit, and that is all full-time faculty except welding, fire science, and law enforcement. And a key thing is those people all have 162 duty days, and they teach full-time. So adjuncts or administrators or staff are not in our bargaining unit. Because we're the exclusive bargaining agent United Faculty of Florida is, this means anything concerning wages, hours, and terms of conditions of employment must be negotiated between the college administration and the union. You cannot directly negotiate your salary with the administration, you can't make any changes for a particular person. This also means that if the administration is going to make any changes to your wages, hours, and terms of condition of employment, it must go through the collective bargaining process and be negotiated with the union. So there are no more unilateral changes. It also means that the union will not negotiate directly with the board. It has to go through the collective bargaining process, which is going to be all public records and publicly announced. And that's the recognition.
Okay, so technically our contract is technically expired. Our duration ended June 30th 2023. However, this gives us this will establish the contract as status quo once it's ratified, and then we will start renegotiating the new contract moving forward. And in moving forward, once we renegotiate the new contract, we will be able to open one or up to 3 articles of our choice or their choice over the next 3 years. Okay, so supremacy and severability is basically what trumps what. So our CBA will trump any other prior agreements and any board rules up until this time. The law trumps our CBA. So if it's in conflict with the law will win. And anything that is deemed invalid by law will basically hopefully be renegotiated later on, but it's possible that there are things in this contract that are now slightly obsolete.
And then let me butt in here. So right here, so chapter 447 of the Florida statutes is all of our collective bargaining union rights. So if you click on here, that will take you to, hold on.
It'll take you to the state Florida statutes where you can read them yourself.
Yep.
There we go.
Everything you'd ever want to know about collective bargaining and labor organization is right here. And in general, if there's a statute you're interested in, you can go here and read all of the laws.
Which we know you want to.
Okay.
Okay. Non-assignment and waiver are basically just kind of boilerplate. So we're kind of skipping down to the things that really are, I don't know, I want to say really important. So a few new things with the non-discrimination clauses. So obviously there's a non-discrimination law, but things like pregnancy, credit history, sexual orientation, gender identity, or genetic information or political affiliation are now protected. So in C, basically, if you decide to pursue a discrimination claim, you basically have one of 2 options, but you can't do both. You can either grieve it, which means you cannot file I think it's called an EOC, a lawsuit at the state level, or you can file a lawsuit, but you can't file a grievance. You can't do both. It's one or the other. However, just because one member of the bargaining unit chooses to do one thing does not mean that that precludes any other bargaining unit member from filing whatever they choose to do. Like, it doesn't establish precedent, it doesn't establish anything. And the union can also either file on their behalf for a grievance, or basically do whatever the employee wants to do. It doesn't limit you. Oh, and all references in this agreement to employees of a particular gender are used for convenience only. And we are not allowed to strike by Florida law. We do have other options, but it is illegal.
All right. So Article 3 is union rights. So dues deduction is under litigation with the state of Florida right now. So it has been outlawed by the state of Florida for certain public employers to deduct union dues from your paycheck. So this was previously allowed. Some of you may have been on payroll deduction, but now, as of now, you must switch to the eDues system, which you can get information about outside of this video. But this is still in the contract because that's what we bargained. And then if that law is struck down, this article or this section will come back into play. For use of facilities, if the union wants to use a room, we just have to ask as long as the space is available. Our college email, the union can use, but we can only right now provide notice of the date, time, and location of union meetings. So if there's other information that we need to share, it really needs to be on personal email. So this is why it's important that you share your personal email with the union so we can communicate about other important issues. Also, if you want to communicate with the union, you should be aware that anything you email through our college email is the college can read and is public record. So anyone in the public could ask to read all your emails. So if there's something personal or sensitive, you should do it with your personal email to the union email address, which is on our website. We can have a bulletin board, not really useful right now. Okay. Section 3.4 is access to faculty. So if there's an orientation, the union can provide a packet of information. We can also have a table at any college events, and we can also have the right for the union to have a session at all college day that would be voluntary for faculty. Okay, access to information. So in Florida, we have very broad public records law. If you want to read about that, you can go right here. That's going to be all the statutes in Florida. This is the public records section. So if there's something that the state pays for with taxpayer money, taxpayers have a right to know what is going on with that. So that means our collective bargaining is public records, all our email, also your personal contact information. So your home address as a public employee is public record. If you want to know more about, they're called the Sunshine Laws, these public records practices. This is the Government in the Sunshine Manual, which has all the details about what is required to be public records for taxpayer-funded meetings and things like that. So, for instance, you have a right as a member of the public to speak at our Board of Trustees meetings, and that is something that the union asserted that legal right because of our Sunshine Laws. So going along with the public records, the college will furnish all this information with the union. Some of these you can just honestly get at websites. For instance, the minutes of our board meeting, the agenda, the annual financial report is available online. The college budget, they email everybody also, but we can also get more detailed budgets if we ask for them, just like anyone else. We also will get a list of members of the bargaining unit when we ask every semester. So we get all the full-time faculty in the bargaining unit, their name, department, home address, campus address, and phone number. If you or someone you are married to is in law enforcement or a lawyer, you are public records exempt. So sometimes we might reach out to people individually to get their home address for ballots for ratification and so on. And all this information is available anyway, but we will request from the college this information so we have it. Also, any handbooks are available to us, and our collective bargaining agreement says that we should get this information within 10 days, which would be prompt. We also get a consultation with the college president. So if we request, we can meet with the college president once per year. If we want to meet more often, we can request. So this would not be a bargaining session. This would just kind of be for communication, and we can meet directly with the president. And we have done that in past. We've shared morale surveys and feedback from the administration with the college, or from the union with the college president. Okay.
Okay, management rights. So these are the rights that the college has by law, and anything related to these rights are permissible terms of bargaining, meaning that they don't have to bargain these things with us. These are their rights. If they choose to bargain with us, yay, but they don't have to. And if you want to go to the section 447.29 and read more about it, you can. But basically, kind of the common sense things. They have the right to establish policies and procedures. They have the right to manage the facilities and decide what's happening there. They have the right to hire everyone, to determine time and hours of operation, when the college is open, when certain services are open, what services, what levels of services are provided, and how. Staffing patterns. Who do we need in what department, when, why. To determine number and classification, basically how many people do we need. Use of machinery, facilities, equipment, basically any property of the college. They have the right to say yes or no if we want to use something. Basically decide how many campuses, how many programs, how many departments, divisions, which ones, etc. Basically all of that for the college. They can determine all of that. In other words, if they want to get rid of a program, they can do that. If they want to add a program, they can do that. If they want to increase a department size, decrease a department size, etc. Okay, all the budgetary stuff. Allocations, revenue, yeah. All the action in response to an emergency. So things like the panic buttons and our lovely that they give us every year, like what to do in these type of emergencies. It's really up to them to decide what our procedure is. Classes, so scheduling classes, assigning faculty, and basically meeting the needs of the students and everyone. So all of that really is their right. Okay, all the administrative rules, procedures, policies, regulations, and practices that are not inconsistent with this agreement. So basically everything outside of the contract. So this doesn't mean that we can't grieve decisions that have the practical consequence of basically, in other words, sorry, let me start over. We can grieve something against the contract that management does. Any violation to the contract. And we can also bargain the impacts of the decisions that the college makes. So we can bargain the consequences of them, the impacts of them, even if we can't technically bargain the actual decision. So for instance, we couldn't really change the healthcare issue, but we could at least bargain with them as to, well, how is this affecting faculty and the impacts of that? And so if it comes under our scope of wages, hours, and terms and conditions of employment, then we can look at the impacts of what they're doing. Okay, they have an obligation to bargain with us. According to Florida statute, we have the right to collectively bargain under state law. And we also, hold on.
This part is just saying that if they do something that they think it's a management right, we have to go through perk to assert that this is their obligation to bargain. So for instance, if they are asserting something that's a management right and we say it's not, it doesn't go through the grievance procedure with an arbitrator. It goes through the Florida statutes with the Public Employees Relations Commission.
Okay.
Yeah.
Thanks. I think
no
I misread that. I was like, I'm like, yeah, I definitely think I misread
okay.
that.
All right. Grievance procedure. So this is a really significant part of having a union and having a union contract. So if the administration makes a decision that is in conflict with our collective bargaining agreement, we can file a grievance and saying this contract is not being followed. The grievance starts off informal, and then there are a series of steps that can ultimately go to a third party arbitrator who is neutral and will make a binding decision. And so that's a key thing about having a contract, is if the administration doesn't follow it, we can enforce it. In contrast with an IMM or board rule, there are really not consequences to not following those procedures. So in the grievance, the desire is to settle things at the lowest level possible. So we just, hopefully you can just say, hey, the contract says this, and then the administrators will say, oh, okay, you're right, and then fix whatever it is. But if that does not happen with a CBA, and if you're a union member, the union will help you escalate that to the point where the contract is enforced. So a grievance is an alleged violation of the contract. The grievant is the member of the bargaining unit or the union itself. We have a grievance form here where you would put all the information, the articles being violated, the statement of the grievance, and the remedy sought. So you would fill that form out. The representative would be someone that the union designates to help out and act for and on behalf of the grievant through this grievance procedure. And so we're going to have several levels. The informal step is the first thing, and this is just going to discuss the grievance with your immediate supervisor. A really, really important part of the grievance process is everything has a timeline. If you miss your timeline, there's not much we can do unless the administration agrees to extend the timeline. So if something happens in violation of the contract, you have 20 days to raise the grievance in the informal step. If you're not satisfied with the decision after you raise the informal step, you can escalate it to level 1. Level 1 is within 10 days of the informal discussion. Level 1, now this is when you fill out the grievance form and you submit to your immediate supervisor. Your supervisor then has 10 days to provide a written response. And this comes up later, but if the administration does not do their response within the timeline, it automatically goes to the next level. It automatically escalates. So you do your level 1, you have your grievance form. If the administration responds and you're still not happy, if you're not satisfied with this, you can appeal and then go to level 2. You have 10 days to do that. Level 2 goes to the executive vice president and chief academic officer, college provost. So it goes beyond your supervisor to the academic officer, and that person will have 10 days to meet with you and discuss the appeal. They then will have 10 days to provide a written disposition. And if you're not happy with what happens at level 2, again, you can escalate now to level 3 within 10 days. Level 3, the grievance form is forwarded to the college president. They can meet with you and or a union representative, but regardless, they'll have 10 days from receiving the grievance to provide a written response. If you're still not satisfied with the outcome, now you can escalate to arbitration within 10 days. Okay, again, 10 days. Arbitration is going to be the final step, and this goes before a neutral third party. The arbitrator will be agreed upon, or at least we have a manner of finding an arbitrator, so it's not like one side is picking who the arbitrator is. The arbitrator will come from the Federal Mediation and Conciliation Services, so there are people that are professional arbitrators. This person then, once the arbitrator is selected, there will be a hearing with the arbitrator. If you are filing a grievance, you can have release time to miss classes, and any witnesses called by the union will also have release time if it falls during your class periods. So if the issue is arbitrable, it's the arbitrator to decide. So the arbitrator is going to evaluate the contract, the collective bargaining agreement. This person has also the right to decide if this should be a decision that an arbitrator makes a decision So there'll be a hearing via conference call, and the arbitrator will decide on arbitrability within 15 days. If both parties agree, you can extend this timeline. If the grievance is deemed not arbitrable, then the arbitrator doesn't make any judgment calls. The arbitrator can also not change the CBA, cannot add to, subtract from, modify, or alter the terms of the contract. Another key thing is the arbitrator is not going to substitute his or her judgment for the administration. It's really just, was the contract followed, unless the administrator made an arbitrary or capricious decision. This means that if an administrator uses their judgment and gives you a poor evaluation, the arbitrator will not substitute his or her judgment. They're not going to question the evaluation of you. You can't grieve a bad evaluation, but you can grieve the process. So if the evaluation process was not followed to the letter of the collective bargaining agreement, then the arbitrator can make a decision on that. The arbitrator's decision is also final and binding. There's no appealing the arbitrator, and the remedy must be followed. If there's fees and expenses, both parties will equally share them, and there's no, either party cannot be ordered to pay the attorney fees for the other party. Time limits may be extended by mutual agreement. If you, the grievant, don't meet your timeline, that's considered a withdrawal of the grievance. That's it. And if the administration doesn't follow their time, that triggers the timeline to advance the grievance. Okay, you can withdraw a grievance. You can also amend it. C is important. So if you are a union member, the union will help you file a grievance if the union, determines that a grievance is warranted. If you are not a union member, the union will not represent you. Also, a grievance cannot be filed over the objection of the union. So if the union says this should not be filed, the grievance can't be filed. You must be a member of the union paying dues at the time that the contract was violated in order to have help from the union filing a grievance. So that's why it's especially important now, once the contract is ratified, to be a union member, because if you want help filing a grievance, you need to be a union member at the time whatever happened. If the union chooses not to help someone file a grievance because someone is a non-member, that doesn't mean that waives the right of filing grievances later. If you have multiple supervisors that are involved in the grievance, it just goes straight to level 2. Okay.
Okay. All right, a reduction in force, which we very rarely have, but we do have provisions for it. So basically, reduction in force is what we term as layoffs. When you are involuntarily separated from your job, usually due to lack of work. And it is the administration's right to lay people off. And there's the state statute if you want to check it out. However, it is the union's right to negotiate the impact of those decisions, and to file a grievance when those basically violate parts of the contract. They need to provide you with 6 months notice, and no less than, at least 45 days prior notice, when you basically are about to be laid off. Like, they need to tell us, notify the union that this is happening, and more if possible, so that basically we can negotiate any impacts. If you are laid off, you will receive full salary and benefits to the ending date of your contract. This is important. If there's a vacancy in a position that you're qualified for, then basically you have first dibs on that. And if there's basically if there's someone else that's on annual contract or holding that position, you can slide into their position. So it kind of
If you're on
it's like a
continuing,
shuffle.
yeah.
Sorry.
Oh, if you're on continuing contract, yeah.
If you're on continuing contract, basically you can bump someone from who's not on continuing contract for their position. And layoffs are considered an involuntary transfer.
If you move to a different one, sorry, yeah.
Okay, keep going. So basically the descending order of importance of layoffs for that as far as the college consideration is accreditation standards. So basically, what do we need? Program and area needs, employee qualifications and credentials, employee performance evals and length of service, disciplinary history that's not reflected in any evaluation, employee service to the college and other work history, and then last supervisory recommendation. And we did the descending order of importance so that it's not just a supervisory recommendation, that they have to take all of these other things into account before laying someone off. Fairness. Okay, recall is basically when if a job opens up, the laid off person will have the right of first refusal. Sometimes they call it the right of recall. So they will basically call you and say, we have this open and you have the right to refuse the position or take the position first before it's offered to anyone else and before it's posted. Oh,
Is that
okay.
good? Yep. Okay.
I think so, yeah.
Okay, so faculty evaluation, this is the responsibility of our administration. The purpose of our faculty evaluations is to help us provide the best instruction for our students. If you're a member of the bargaining unit, for instance, if you're a program director or a department chair, you cannot be assigned to evaluate another full-time faculty member. So program directors and department chairs cannot evaluate other full-time faculty because you're both in the bargaining unit. The purpose is to help you improve your performance. Supervisors are expected to monitor and provide feedback during the year as well. Your supervisor will perform the evaluation, and sometimes if you have two supervisors, both will be considered. The timeline for our evaluations are at least once per year. So we have annual evaluations. If the administration chooses to, they can also add additional evaluations. Evaluations will be written or electronic in form. And this was bargained before. So now we had a committee with half faculty and half college appointed members to create the evaluation form and talk about the process. So the components of the faculty evaluations are formal observations from classroom visits documented on the appropriate form, your self-evaluation. There can be student evaluations submitted on the appropriate form. For non-continuing contract employees, your professional development and learning plan, final written evaluation. An evaluation conference is a component of your faculty evaluation. You have the right to respond, and then any other information. Your annual evaluations will be filed in your limited access personnel file, which comes up again later, but basically that's a file that's not public records. That's your personnel file. All right, and we'll stop here for the contract discussion. Yeah, what?
I said part one, end of part one.
Part one. We'll start part two in the next video. Thank you.